welcome to one day one answer initiative of GS Core. So today we will be looking into the concept of basic structure of Indian Constitution, and we will be first and foremost what we'll do is we'll discuss the concept, we'll take into consideration what points are utilized by UPSC to ask question on it, and then we'll go ahead and look into a PYQ. Also, what I will want you to do is write answer to the question that has been provided in the comment section. So basic structure doctrine. First, let us look at the concept. What is the concept? Basically, it is basically a judicial principle that limits the amending power of Parliament. Amending power of Parliament provided to the Parliament by Article 368 of the Constitution itself. Now, why has judiciary provided with this doctrine, and how the limit is put on Parliament? All right. So, what judiciary states is there are certain features that provide identity. To the Constitution, and if these features are lost due to amendment, what will happen is the nature of Constitution will change. All right. And here you have to technically remember the difference between Parliament and Constituent Assembly. While providing the judgment of Keshavananda Bhartina, what basically judiciary looked into? Judiciary looked into technicalities of where as a body Parliament differs from Constituent Assembly. Okay. What judiciary stated is creating a new constitution is the job of Constituent Assembly. All right. If Parliament amends the constitution to such an extent that its basic features change, or if its basic structure change, what that amendment will amount to, or what set of those amendments will amount to, is creation of new constitution, the power of which is not with Parliament but with Constituent Assembly. Parliament is the product of Constitution, and therefore it has to work within the framework of the Constitution as provided by Constituent Assembly. Constituent Assembly ka powers is not with Parliament. Okay, that is what judiciary basically stated. I will repeat, this is very important. Okay. If Constitution is amended to such an extent, that it changes the basic features, those features which provide identity to the Constitution, then those amendments would lead to creation of new constitution, the power of which is with Constituent Assembly and not with Parliament. Parliament can only amend the Constitution as per socio-economic political necessities under Article 368. So that is what in short basic structure doctrine is. Okay. If UPSC looks into basic structure doctrine, now one question that can come is with respect to evolution. Not so difficult. So if I take into consideration evolution of the thought process of judiciary that led to creation of basic structure doctrine, so sabse pehle we will have two cases. All right. Shankari Prasad and Sajjan Singh. Both of them had similar finding. What was the finding? Parliament has paramount powers when it comes to amendment of the Constitution, and Parliament can basically amend anything in the Constitution. Okay. Then we move on to the phrase of Golaknath. Where basically Supreme Court stated that Parliament can amend any part of the Constitution except Part 3, that is fundamental rights. And then when we come to Keshavananda Bharti case. Keshavananda Bharti case, in which it was stated that in Keshavananda Bharti case it was stated any part of constitution can be amended including part 3. ठीक है, तो सुप्रीम कोर्ट बेसिकली रिवर्स्ड इट्स पोजीशन फ्रॉम गोलकनाथ केस, दो what Supreme Court also stated was कि this amendment cannot infringe upon the basic structure or basic features of Indian Constitution. ठीक है, now another point that you have to remember from basic structure is its significance so we'll look into, don't worry about that, but you have to also remember its key indicators or key pointers relating to it. The first pointer related to it, my dear friends, the first pointer related to it is that basic structure doctrine is not mentioned in the constitution. It is a judicial invention. But invention does not mean it is something that has been taken up by judiciary completely out of the blue. So it is not alien. We'll look into it why it is not alien. All right. It is not mentioned in constitution, neither the term was used in constituent assembly. ठीक है. Second, there is no exhaustive list. There is basically no exhaustive list. ठीक है. So these are key pointers, key features of basic structure doctrine. ठीक है. Key features of basic structure doctrine, they are not mentioned in the constitution, and second is there is no exhaustive list. All right. Now these are also basically criticisms. ठीक है. Criticisms with respect to basic structure doctrine. Now another question that can come up is from the point of view of criticism. So we'll look into criticism. And this is the most important aspect of basic structure doctrine. Na? Most of the time when UPSC has asked question, na, it is with respect to criticism and one specific criticism. So first criticism is obviously Constituent Assembly did not imply any such doctrine. ठीक है. Constituent Assembly never stated it. It never mentioned the same in the constitution. All right. Second criticism is that it creates upper hand for whom? Judiciary. It creates an upper hand for judiciary with respect to its relations with parliament. Third criticism with respect to basic structure doctrine is it is ambiguous. It is ambiguous, and there is certainly no exhaustive list with respect to it. ठीक है, so that parliament can take care and not infringe upon it. So Supreme Court has not given any exhaustive list, though Justice Sikri in his judgment provided some pointers. All right, he did provide some pointers. ठीक है. So these are major criticisms. These basically are major criticisms. Obviously, what will also be included in the criticism is when you talk about, when you basically talk about basic structure doctrine is opinion of people of India. ठीक है. Does that opinion matter with respect to policy making or adjudicating that policy? Obviously, people of India are not represented by judiciary. So judiciary speaking about a constitutional amendment, whether it is in sync with the opinion of India, it is not taken into consideration. All right, that is one of the criticism, but there is a rare chance of it being asked into question. So if we take a look at this criticism now and we deal with them independently, the Constituent Assembly, even if it did not provide for the doctrine as such, what did it provide for? Judiciary to be the guardian. Judiciary to be the guardian of constitution. This cannot be denied. All right. And because this cannot be denied, if judiciary basically comes up with the doctrine which safeguards the constitution, then basically there is nothing wrong as such in it. All right, also remember, judiciary has not used this particular doctrine for its enrichment as such. Okay, we have not come across, we basically have not come across this instance. Second thing, upper hand. There is no upper hand. Dekho, judiciary has not denied. What it has not denied? Parliamentary supremacy. Parliamentary supremacy with respect to lawmaking. All right. So Parliament is open to make law. All right. Judiciary is not entering into that framework. Once the law is passed, once the constitutional amendment is passed, then what happens is interpretation of that constitutional amendment, whether it is within the framework of the constitution or not, whether it is as per the vision of founding fathers or not, that is the job of judiciary. So judiciary is in its area. It has not infringed upon the area of parliament. It has basically not entered into the area of parliament. Therefore, the criticism of upper hand does not hold. And with respect to ambiguous, dekho, there cannot be exhaustive list. Why there cannot be exhaustive list? Because you cannot consider all the pointers related to basic structure at one go. They will only be determined once an issue comes up before judiciary. Only then, through interpretation of constitution, it may be known whether a particular pointer, whether a particular value principle is basic feature or not, or it is a basic structure or not. Okay? Otherwise, there can be you cannot sit with the constitution and start interpreting clause by clause. There will be infinite possibilities. It is only through case by case basis that interpretation of the constitution can be done. And successive features can be termed as basic features, or they cannot be termed as basic features. They could be avoided from being added in the list of basic features. Other than the case laws that we have seen, I will provide you few more case laws. They will help you. Now let us go to next arena of questions being asked when it comes to basic features. That is significance. When it comes to significance, what all needs to be mentioned? First and foremost, what does it do? It checks. It keeps a check on Parliament's amending power. All right. So the concept of checks and balances basically remains alive due to this particular feature. Second is, it preserves constitutional values. Third, I will say it enhances judicial confidence even for the future generation when it comes to use of judicial review. The power of judicial review, which is provided by Constituent Assembly itself in Article 13, though it is not explicitly mentioned. Okay. With respect to case laws, I am providing you with a document. You can find it in the description section. That document will help you with respect to case laws. All right, it is exhaustive. Okay, usse bahar you don't have to see when it basically comes to case laws. All right, friends. Now let us look at the question. Let us look at the PYQ. The question is, Parliament's power to amend the constitution is limited power and it cannot be enlarged into absolute power. Basic structure doctrine. Okay. In the light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending powers. Dekho, in such answers where the doctrine is favorable, likho ki nahi kar sakte. You have to write ki it cannot be done. All right, it basically cannot be done. Now, with respect to basic structure doctrine and this particular question, what has to be done? In the introduction, my dear friends, in the introduction, what I will want you to do is mention Article 368 368, and with the help of 368 talk about amending powers of parliament. Amending powers of parliament. All right. Other than that, the next step that you have to take with respect to amendment with respect to 368 is mention that 368 is not absolute and it has some constraints. And the constraints that we can focus upon, one of the constraints that we can focus upon, or we have to focus upon rather, is the basic structure doctrine. All right, then come to, in the main body, what is basic structure doctrine? We have gone through it. What is basic structure doctrine? Second, that has to be taken into consideration. And mentioned are obviously why basic structure doctrine has come up. Okay, again, this has been done by us. This basically has been done by us. Third, what has to be done is mention some case laws which showcase basic structure doctrine. So Keshavananda Bharati ho gaya. Then come to Minerva Mills case. Why is Minerva Mills case important? Because it stated that judicial review is an important aspect with respect to basic structure doctrine. All right, then second thing with respect to second case that you will take with respect to basic structure doctrine would be, I would suggest, would be SR Bommai case. Why SR Bommai case? Because it stated that secularism is basic structure, one of the basic features. Okay, third case that you could take it is National Judicial Appointments Commission, and through National Judicial Appointments Commission, through the National Judicial Appointments Commission, what happened was, in that case what happened was, judicial independence was asserted to be one of the basic structures, one of the basic features. Then now come to the question of whether parliament can under 368 destroy basic structure doctrine. All right, destroy basic structure doctrine. So the answer to this question is obviously no. Okay. And why the question has to be answered in negativity? Why the question has to be answered in negativity? Because it is now an internalized, aspect that Parliament has been provided amending powers for the purpose of making modifications. And not creating a new constitution. All right. And secondly, what will also happen is, as a guardian of constitution, the Supreme Court basically would adhere to the principles of checks and balances and defend the doctrine of basic structure, even if attempt is made for the purpose of doing away with basic structure doctrine, doing away with the doctrine of basic structure doctrine. All right. Third thing you must understand, basic structure doctrine is not explicitly mentioned in the Constitution. It is not explicitly mentioned in the Constitution. Hence, doing away with basic structure doctrine through amendment itself is a bit difficult. Okay, you can amend a provision quite easily if it has a particular mention in the Constitution or in the statute book. Now doing it explicitly, when the concept is not explicitly mentioned, it is a bit difficult. It is basically a bit difficult. Third thing with respect to basic structure doctrine is the question of Federalism of the country being affected through basic structure doctrine, as the Supreme Court has also termed federalism to be basic feature of Indian constitution. Alright, so if federalism is affected through basic structure doctrine, and if therefore basic structure doctrine is attempted to be touched by the parliament, what basically will happen? Parliament alone cannot do it, state has to come in, states have to come in. And if modification is attempted to be done, it has to be done, it has to be basically done with in association with at least half of the states. Alright, so that is more or less what will be the answer to this question. One more thing guys, when the questions are asked in polity, try to relate current affairs. So in this particular question, what I will do is, I will basically take up comments made by Vice President of India, because he is critical of basic structure doctrine. So what you can do is, while writing the answer, incorporate the comments of Vice President of India stating that basic structure doctrine should not be adopted in a parliamentary democracy like India. Okay. Second thing, very recently what Supreme Court also came to the conclusion was, basic structure doctrine can be used only for interpretation of constitutional amendment and not for ordinary law. It can be used only for interpretation of constitutional amendment and not ordinary law. This does not fit here, but I am just telling you a current affairs. Alright, in the evening guys, what we will do is, we will have a discussion on Telegram. We will have a discussion on Telegram on basic structure doctrine, its implications, its significance, and question that might arise from it. Alright, thank you, best of luck. Please do write answers, I will be waiting for them. I will be waiting to chat with you on basic structure doctrine. Chalo, bye.